Welcome again to the Courtroom Moments channel. Meet Judge Boyd, a no-nonsense figure in the courtroom. Across these three cases, Judge Boyd demonstrates an unwavering focus on accountability and justice. Whether addressing repeat offenders, overbearing parents, or unethical behavior, the judge delivers lessons for everyone watching. Number 3, repeat offender confronted. A repeat offender faces the consequences of failing to meet probation conditions. Judge Boyd outlines the risks of continued defiance with a stern warning.
So, have you read the supplemental report? Everyone, please whisper. Have you read the supplemental report and discovered what the probation has complaints about?
She said I haven't gave her my address. But
I'm sorry, what?
she said I haven't gave her my address.
All right, so why does it take you having to come in for you to give them their address?
I have.
No, you're here because you would not give it. And according to this, it says CSO inquired about the address and he declined, stating he didn't want her family in his business.
No, I didn't say that. I have it here, right here. I sent it way July 9th. And I sent her my address.
Yeah, here's the thing. You're looking at 4 years in prison. You're continuing to test positive, according to this. So you need to ask yourself, is it worth going to prison for 4 years? If it is, there's always accommodations for people to be at the prison. And let me explain something to you. I know people will say, "Mayor, not a big deal. Oh, I can continue to smoke." Here's the thing. These are the rules. This is the law. In Texas, it is not legal. The only way you can use if there is a doctor's prescription, and even then you have to use it within the prescribed parameters that they're giving you. And you're testing for more than, and if you're drug tested today, what are the results going to be? See, okay, here's the thing. I can go send you to do a UA right now, and you want to weigh your things that it's going to be negative and tell me this. If it's positive, I can just tell them to file a motion to revoke. And then you know what will end up happening with a motion to revoke? What will end up happening is you will be taken into custody. Either you will make bond or you won't make bond. Do you understand?
Yes, ma'am.
So you're telling me your results are going to be negative?
Yeah.
Now we're moving around from they should.
I haven't been.
When's the last time you used?
It's probably about month and a half.
Oh, if you use a month and a half ago, it should be negative.
It's like a CBD that I bought from the store. I didn't know.
See, now you know. I don't know why people want to risk their freedom. You know, well, you're saying yes, ma'am, but what you're doing, you're risking your freedom. You're risking your freedom for CBD oil. You're risking your freedom for not telling them where you live. You're risking your freedom for not being at home visits. Probation is not easy. Probation is not supposed to be easy because guess what? You're on probation because you broke the law. And I know people will complain, I have to report to probation. This is so hard. Guess what? You broke the law. That's why probation is hard. Probation is not supposed to be easy. Probation is supposed to rehabilitate you. Probation being easy is not for you because you're on probation and you broke the law. So you have choices in your life. You can go to prison, and guess what? The most you can get is 4 years. You go to prison maybe for 4 years. Maybe you'll be out in 2, maybe longer. Who knows? They'll tell you when to wake up. They'll give you food to eat. Either your family will put money on your books for you to have a decent meal, or either you're going to have your bologna sandwich. What do they call those meals, Deputy Laura?
Johnny.
You can either have your Johnny, or either your parents will, or somebody, or your girlfriend will put money on your books. So why can you not complete this probation?
I completed it.
Probation. What does he need?
Judge, a TAP evaluation was completed just recently, and the recommendations of the TAP is intensive outpatient treatment, monthly urinalysis, and documented sober support meetings. I would like to talk to Mr. Reese a little bit more so that maybe if there was some miscommunication in regards to the addresses, I can get that cleared up so that we can go ahead and conduct the field visits as mandated.
All right. This is what the court is going to do. I'm going to follow the recommendation of TAP. There's going to be intensive outpatient treatment, and there's going to be 120 sober meetings in 120 days. Are you employed?
No, I'm not. I'm looking. Did my trade, so I'm looking for my forklift job now. So I don't have trade.
So here's the thing. How long have you been without employment? All right. So while you're waiting for another job to come around, you're going to have to get employment outside of your field because you're an adult. You have to eat. Nobody else should be supporting you. You understand? All right. Is there anything else you need from the court? Probation, is there anything else?
No, Judge, but did you want me to do anything with the monthly?
We're going to do, you know what? Once he tests negative, patch him. And then we'll see what happens. So we'll do regular random UAs and make sure they test for levels. And then once he's negative, then patch.
Until further notice?
Yes. Anything else? All right. Thank you. Do better. You understand?
Yes, ma'am. I will.
You should be thinking that, you know what? You have a key in your pocket to the prison, and you can either use that key to open it or not. And you should put a key in your pocket. And every time you look at that key and you see all those CBD places, you need to ask yourself, hey, I have a key. Do I want to use it to go to prison? It's completely up to you. You understand? All right. Good luck.
Thank you.
You're welcome.
Number 2, parent oversteps in court. Judge Boyd encounters a father attempting to interfere in his adult child's legal case. A clear boundary is set, showing where family involvement should end and professional action begins.
Hello, Judge.
Hi, how are you doing?
Doing good. Nice to meet you.
All right. Nice to meet you too. So you're the father?
I am.
Okay. All right. So this is what I always tell parents. And I used to be a defense attorney, so I know how it is with parents. When parents have children, their child can be 30, their child can be 40, that's still their baby, and they want to be involved. And it's especially true when you have a child who is young, 17, 18. But here's the thing, in this world, they're all considered adults. And when they have an attorney or something, the relationship is between them and their attorney. I used to have to tell parents all the time because sometimes the parents would hire me. And I used to have to sit down with parents and say, hey, you've hired me, you're paying me, but that's the end of our relationship. You can't be a part of discussions I have with my client because guess what? I would tell them, if you're a part of discussions I have with my client, then there's no attorney-client privilege. And you know what ends up happening with that? When there's no attorney-client privilege, guess what? You can be called as a witness. Anybody who's in that room having a conversation, it's all fair game. They can be called as a witness. And maybe sometimes there is something that maybe a client wants only their attorney to know, and they don't want other people to know. But when parents are in the room, guess what? That all goes by the wayside. And sometimes we have to let our children go and let our children be adults. So on this side of the fence, I would always tell parents, it's great. I need you to be supportive. I need you to make sure that my client, your child, is keeping their mental health great. They know that everybody is rooting for them and are a part of their team. And I would tell them, but that's where it ends. And it can't go past that because when it does, there's an issue. And let me just tell you my experience with one case I had in the past. Had this client very young. Mother wanted to be 100% in the conversations, even though I would tell them, hey, you shouldn't be in this conversation and you cannot be talking to your child about what happened because guess what? You can be called as a witness. They wouldn't listen to me. And so when it came time to do a plea bargain agreement, the parent is in the hallway. And I can tell you this because they were in the hallway shouting. So everybody heard. So it's not confidential. So they're like, I want my child to do A, B, and C. And, you know, I told them, I said, that's your child's choice. Because guess what? If your child chooses A, B, or C, and if something ends up happening and they end up going to prison, the judge is not going to say, you know what? Your child only chose A, B, and C because of you. So we're going to let you suffer the consequences. You understand? And for some reason with attorneys, people assume that being an attorney is easy. And being a doctor is so much differently. Because if you go to see a doctor and you get a second opinion and a doctor tells you, oh, yeah, your child needs a heart transplant, or, oh, yeah, we need to take the appendix out. A parent doesn't go to that doctor and say, well, I want to look at everything. And let me just tell you how I think this appendix should be taken out. The person depends on the doctor, that the doctor knows what they're doing. And that's the same case That's the same situation with these cases, and everybody needs to understand that. Cannot be crossing lines. Does everybody understand?
I
Understand?
understand it.
All right. So that's the way it's going to be. So this is what's going to end up happening. And we're going to come back on June 27th. Council, is that enough time?
Yeah, yes, Your Honor.
All right. So we're coming back on June 27th. And let me just tell you the way this is
Oh,
run.
well, you say 27th or 22nd?
27th.
I am double booked. I've got a hearing on the 27th.
Okay.
But
All right. We can bring it back on the 24th.
yes, thank you.
All right. So we're going to come back on June 24th. This is the way things run in this court. I make sure that everybody has the discovery. So when the defense counsel and everybody tells me I've received all the discovery, next thing I do, I require the state to tender an offer to the defense. And the defense has an ethical and legal obligation to tender that offer to their client and tell their client what the consequences are of the offer. Then I give everybody a plea deadline date because I want people to think about whether they want to accept the plea or not accept the plea. If they decide not to accept the plea, when I give them the plea deadline date, then that plea deadline date has expired and the next setting is going to be a jury trial. And if somebody after that plea deadline date has expired decide, oh gosh, I don't want to go to trial, the only way I'll accept a plea is for good cause. Otherwise, they'll have to plea open to the court. All right, everybody understand? Any questions to add?
I do have one
Sure.
question, Judge.
Yes.
When your child has a serious, persistent mental illness and a developmental disorder, and that is recognized and should be recognized early on in the Article 1622 of the Code of Criminal Procedure. And there's been multiple suicide attempts.
All right, let me stop you right there. So here's the thing. With regards to that, that is something for her attorney to address. What you and should do as a parent is turn information over to the defense attorney if you think it's something that she needs to know or is something that her client wants her to know. You understand? So here's the thing, you got to cut the string. And when I say cut the string in the court, I mean court the card as in your daughter and her attorney need to be able to have conversations in private. Now, if her attorney wants information from you, then the attorney will ask you, say, hey, I need some information from you. These are records. Maybe I need these records. I'm trying to get these records. Do you have these records? This is something that I want to view. That's completely up to the attorney. But what you right now and quoting code sections to me, guess what that tells me? You're trying to be an attorney and you're not an attorney. Did you go to law school?
I didn't go to law school.
So there's the thing. People think that they can read penal codes. They can read the Code of Criminal Procedure and that's it. And not to step on anybody's toes, but for criminal law, when you're practicing criminal law, you know what your Bible is? Your profession is this book. And you see how thick this book is? And so if I were not an attorney, guess what? I would see one section and I'm like, oh, that section says that. D is for done. But that's not the way it works. This entire code, guess what? You may read something in this section and still you have to go to this section because it all relates to it. It's similar to the Bible. And let me bring the Bible up for you. Some people will just read one section of the Bible and guess what? When you read that one section, that same person who is listed in that one section, there's somebody else in a different book that has something about that person in the other section. So when you just come away with one part of that section, you think, oh, I'm done, and you're not. And that's why you have to study this forward and backwards. And how many years have you been an attorney?
Over 20, and I'm board certified in criminal law.
All right, over 20, board certified in criminal law. So when people are throwing code sections out to her, let me just tell you, I know her. Every attorney in here knows her. And all attorneys know each other because when you've been in Bexar County practicing for over 20 years, people know you. What I can tell you is she would not be board certified in criminal law if she didn't know this book. and know the updated part of the book. And what do you do for a living?
I have been the president of an international Fortune 400 company in
Okay.
Mexico City.
So let me ask you this.
Yeah.
How would you feel is if you are doing that job, and how many years have you done that?
20.
You've done that for 20 years. And I just walk into your place of business and I'm telling you how to run things and telling you what the law is about something that you've been doing for all your adult life. Maybe you wouldn't take offense about it, but I guarantee you when I left the room, you know what you probably say? Who does she think she is? She doesn't have a degree in this. She hasn't even worked in this field and is trying to tell me how to do it. And for me, that's with any job. For example, I wouldn't go to McDonald's and tell them how to cook their fries. I haven't cooked their fries. I don't know how to cook it. I would not go to a contractor and tell them how to pour concrete. I may think I know how to pour concrete, but the little things I know about pouring concrete, you have to have it at a certain temperature. Otherwise, it's going to crack. You have to mix it appropriately. That's why when you see people out here mixing all their concrete with quick concrete, sometimes it doesn't go right because there are certain things that experience, knowledge, and education treat you about it. So here's the thing at the end of the day. At the end of the day, this is her attorney. From what I've seen, it appears to the court that she's following through on all mental health issues if there are any. You know why I know? Because I put in here, refer to mental health court. And I know that she's been working on doing that. That's why it's in here. Otherwise, it wouldn't be. And you know how I know that? Because she requested it. So when you come to me about the code of mental health, I already know she knows about that because otherwise it never would have been requested. Sure.
And of course,
As long as you're not quoting the law to me.
I won't go the long, Your Honor.
Okay.
Of course, she did go to mental health, and that's where we discussed, and that's the absolute right place to be. Just a month ago during a suicide attempt, I said I really finally have insurance, and I'd like to get inpatient care for her because it's a very serious issue.
Okay.
And I was correct. No, let's hold off until we can get.
So here's the thing, though. The advice that she's given your daughter and the advice that maybe she's given you, that's from her legal perspective. And she's trying to protect your daughter's legal rights because this is a criminal case, right? So that's what's happening. So what we're going to do, I'm sure she probably already has, but I'm sure she'll do it again. If your daughter wants to, she's going to discuss with her offer is, and we're going to come back. Either she's going to accept the offer, not accept the offer, and either we're going to be in jury trial or we're not going to be in jury trial. That's where we are. But I will tell you this, whenever you're meeting people and you're meeting people in their profession and you want to talk to them, don't quote them things about their profession. I know that she's not going to take it as a slight, but people tend to not like that because people pay more what the cost mortgage for their degrees, and they spend a lot of time, experience, and knowledge doing what they do. And I don't know of any defense attorney who would purposely try to lead their client down the wrong path. And I've never seen her try to purposely lead her client down the wrong path. And just my experience of a judge with her, I've never had to tell her what the law is. Okay? All right. Is there anything else?
There is.
Yes.
My client had a mental health evaluation that her possession of and is refusing to relinquish from my understanding. I would like to get that today.
All right. So here's the thing. I can't force you to turn over things to her, but get this. She needs information in order to represent your daughter, right? That's what she needs in order to represent your daughter. Whether you want to turn it over or not, that's completely up to you. Here's another thing I would always tell my clients and my clients' parents. This center of the courtroom, which we call the well of the courtroom, is a minefield. Your child, I am directing them on where to walk in this well. That's a minefield. I'm behind protected glass. I'm going to be just fine. But when I'm telling them to turn right, it's based upon all the information that you've given me or withheld from me. And when I tell them to turn right, I would always tell them they have no choice. They're going to go right. Now, when they turn right because of some information you haven't given me, and I'm going by the information that I have, is there going to be an explosion? If there's an explosion and it's because of some information you had that you didn't give me, that's all on you. So if you, or if about their children, this attorney, it's confidential. So if she receives something, guess what? It's confidential. It's something that she's received. Maybe it's something she wants to discuss with her client or not. It's not something that she is going to turn over to the state unless that's something she thinks should be done. So if you want to hold on to that, then that's up to you for holding on to it. But if you say you want to help your child and she's telling you she needs that information, I mean, what do you think she's going to do with the information? You know?
Well, I would say, love to hear what her understanding of Michelle's mental.
Here's the thing.
Yeah.
I want you to internalize what I'm saying. She doesn't have to talk to you. You're not her client. What she's telling you is you have information and I'm assuming you want her to see the information. So either you want her to see it and study it and give it to her, or you don't. If you don't, that's fine. I can't legally force you to turn that over to her. But what I'm telling you is if this is a child and you say you love your child, which I'm assuming you do, I've just told you the information you turn over to her is information you've given to her. Her medical records are confidential. She's an adult, so I don't even know why you have them in the first place because she is an adult. Those medical records are her medical records. They are not yours. She is not a child in the eyes of the law. So if you have something that would help her attorney represent her better and you love her, you probably should turn it over. The end. That's it. The end. All right. So either are you going to turn that over to her or not? That's either yes or no.
I'm gonna give it to my daughter. If she wants to, it's a client, privilege between the two, and if she wants to.
All right. So just hand that over to your daughter now then. All right. Is there any other documentation that are medical records that belong to your daughter? And when I say belong to your daughter, her name is on it and it's related to her treatment. Do you have anything else?
Not with me.
All right. So this is what you need to do. Again, I can't force you to do it. Her documents are her medical documents, and do not interfere with her and her attorney relationship. You understand? So you can't give her her documents and then say, oh, I don't want your attorney to have it, or I don't want this to occur. You need to be a part of her having great mental health. And the way to do that is not put stressors on her, and don't put stressors on her by interfering with her relationship with her attorney. Because guess what? This atmosphere, being on the criminal side, is already stress enough, whether somebody committed an offense or not. Can you imagine the stress that people have because they think maybe they're going to prison? People in the box, guess what? They're over there. They're brought over from the Bexar County Jail, not on bond, can't make bond or something else. Even though you may say, oh, my daughter's not like those people, or my daughter doesn't have criminal history. Guess what? Even if there's somebody over in that box who's been to prison before, guess what? Their heart is still beating fast because they don't know if they're going to go back to prison or not. So this is a stressful situation for her. Don't make it any more stressful. You understand? All right. Thank you very much.
Thank you, Your Honor.
You're welcome.
Number 1, teacher's betrayal. A teacher who stole from young students faces Judge Boyd's pointed questions. The courtroom hears about betrayal, remorse, and the impact on the victims.
0290 State versus Virginia Valley-Torres. Can I have parties announced for the record? State. Defense.
Your Honor, good morning. Frankie Sandoval on behalf of Ms. Bella Torres.
And are you Miss Valley-Torres? All right, I'm going to need you to keep your voice up so that I can hear.
Yes, ma'am.
All right. You entered a plea on October 3rd of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. According to the plea bargain agreement, punishment is to be assessed at a cap of 16 months. All right, State, what are you requesting?
16 months, Your Honor.
All right, defense, what are you requesting?
Your Honor, if the court would consider, if I may, Your Honor, 16 months would not be adequate punishment. I'm going to say it again, would not be adequate punishment for Ms. Valley-Torres. And that is from her words to me. When she read what Ms. Gaitan's daughter said about still having memories of her teacher taking her bracelet, stealing her bracelet. It cut Miss Vela Torres, it pained her like a knife to the bone. She's the internal punishment that she is putting herself through for allowing the financial difficulties that COVID brought around during that time to trigger her doing these acts is one that she's still recovering from. However, Your Honor, confinement in the interest of justice for 16 months wouldn't serve justice in the sense that there is much, as you've heard from Ms. Torres's daughter and from the pre-sentence investigation, contribution that Ms. Torres can make to society. She's a good worker, worked multiple jobs, had elevated positions in multiple jobs, had this one, albeit big hiccup, but it's one that she's been paying the price for. She's been, during the time of, between the occurrence and her arrest, she had been checking on, trying to see what the status was. It's not for lack of responsibility that this matter has prolonged as long as it has. She carries this with her and will carry it with her as a crime of moral turpitude for the rest of her life. And again, especially with the words of that young child, it is one that, as she's explained to me, when she closes her eyes, it pains her and will continue to pain her, more likely than not, Your Honor, for the rest of her life.
All right, so this is what the court does not understand, and maybe your client can address these issues, because I'm trying to make a determination on what her sentence should be. But according to the police reports and the stipulation, this is not the first time that she's taken, a bracelet or a charm from a student.
Well, would you mind putting Ms. Vela Torres under oath, Your Honor?
Sure. Can you raise your right hand? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're going to need to speak up.
Yes, ma'am.
All right, if you'll state your name for the record.
Virginia Vela Torres.
All right, so according to the stipulations, this is not the first time you've taken a bracelet or a charm from a student. And this student says that they were in the restroom washing their hands and that you took their bracelet, I'm assuming so it wouldn't get wet. And then they asked you to return the bracelet to them, and you continued, according to the student, brushing them off, wouldn't return the bracelet. So the student goes home to their parent, and their parent is, where's this James Avery bracelet? And then they say, you took it and you wouldn't return it. And then there's this big thing where you called into the office and they say that you broke down crying, saying that you didn't take the bracelet. And of course, they have videos everywhere. They show this student going into the restroom and they say it's plain to see that she had her bracelet. And then they show you going into the restroom. And then she comes out and they say they see the student drinking from a water fountain, and that student no longer has her bracelet. And so the student is saying she kept asking you to return her bracelet and you kept brushing her off. And then there is someone else, according to the stipulations, that they're saying you also took their child's charm. So explain.
It was just a rough patch during COVID. Our hours were cut short. I wasn't working very many hours. My husband's disabled, gets a monthly check just to make ends meet. I found it easy to do that.
But then it's like, how old was this child? All right, she's 5 years old. You're an adult, and she's saying that she wants her bracelet back. And you're just telling her you're not giving it back to her. I don't understand at what point in your mind would you have been thinking, maybe you would have been like, oh my gosh, I really need to return this bracelet to her. But you just,
I was at the time, but
but you just kept brushing off a 5-year-old. What did you think was going to happen? Her family was going to think that she lost the bracelet and probably punish her for losing the bracelet while you have taken her bracelet and then pawned it?
I just figured they would think it would just lost.
You just figured what?
They would just assume she had lost it.
And then people would think that, you know what, we're not going to get her any bracelets anymore because she's not ready to have a bracelet because she's constantly losing items. And then at some point, you would think that maybe your conscience would click in when you see the little girl comes there and they're there with their mother and they're accusing you of taking the bracelet. Then you went to the crying part saying you didn't take it. Was that all acting on your part, the crying, I didn't take
No, I
it?
just didn't know how to admit that I had hunted.
Okay. All right. Any questions?
Did you find yourself, Ms. Torres, just for clarification to the court, did you find yourself having crossed a bridge that you did not know how to get back across?
Yes, I did.
And if you had had the knowledge or the insight or the foresight as how to correct it, would you have done so?
Yes, sir, I would have.
But by this time, it was just the bridge too far had been taken.
Yes. I didn't have enough time to be able to get it back out and return it. Like find a way to say I found it while cleaning, or it was in toys or in between something, and return it. I didn't have enough time.
And as you've described to me, this is a punishment that you're dealing with, and it almost with every breath that you're taking.
Yes, because being a childcare provider or teacher was my passion for my career. And because of the stupidity that I did, I could never go back to that career again.
Thank you, Your Honor. No further questions.
All right. Any questions, State?
Thanks.
All right. This is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 16 months in the state jail facility, give you credit for any time served. This is run concurrent with 70040, 70039, restitution, if any, and also the Cash America Pond. And there's to be no employment as a child care provider. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? And did you understand it?
Yes,
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes,
All right, we can go off the record. Here's the thing. Once you do something and you start being deceptive about it, there more lies follow, and more lies and more lies. And pretty soon everything is spiral out of control. In this case, you had so many opportunities to stop. When she was asking you for her bracelet back, you should have just gave it back to her instead of calculating in your mind, you know what? This family bought her this James Avery bracelet. They're not going to miss it. They have enough money. And then that still didn't stop you. Then you start calculating in your mind, her family's going to think that she's irresponsible. Let them think she's irresponsible. And then they won't give her any more jewelry. Because do you know how that felt for her? You're an adult. You're in a position of power. You're supposed to be trustworthy. Now, who knows? Maybe she's not going to trust teachers anymore. You understand?
Yes.
All right. Good luck to you.
Thank you, Your Honor.
Judge Boyd's courtroom presence reminds us that justice is not just about punishment, but accountability and integrity. These cases showcase the importance of standing firm on principles, no matter the circumstances. If you like the video, like, comment, and subscribe for more courtroom moments like this.